All right, in this presentation, we're going to talk about some of the family business organizational documents on structuring a family business. We're going to look at family charters, sometimes called mission statements, sometimes called value or tradition, family tradition statements. We're going to look at some of the issues involving a choice of entity between corporations, limited liability company, LLCs, partnerships, in terms of taxation and limits on liability. We'll talk about some of the filings that are needed to organize and get your business set up with both the state and with the IRS, and some of the tax and organizational issues with the filings, and also some additional documents such as shareholder agreements and other issues in terms of structuring and organizing your family business. So to begin with, let's talk about a family charter. Family charters are essentially a document that is intended to put down in writing the mission of the family, the goals, aspirations, hopes, how the family will structure the business in sort of more of an informal way. It's not really necessarily to be intended to be a legal document like bylaws for a corporation or a shareholder agreement or other type of contractual legal agreement, but it's more of a family overall goal setting type of a document. And it also forms some structural, it depends on how the family charter would be set up, but it does provide some organizational templates. It may have requirements for family members if they want to become a part owner, how that transition might take place. It might discuss various roles and officers, president, vice president, and what their duties are, what their qualifications are. It may set forth any requirements for a family business member to obtain education, maybe a business degree or working outside of the family business before they can become an owner. It may also have restrictions or discussions about having non-family members be owners of a family business. It may have restrictions or discuss how family members engage in estate planning, and whether or not prenuptial agreements might be required for any family member that was going to be married. And other similar type of issues, which may sort of intertwine with some of the legal documents that we would normally use in a business setup, such as a corporation or an LLC, but more targeted towards the family unit and what their ultimate goals for the business are. Sometimes you might have historical context put into a family charter, maybe a little history of the family business, evolution or things like that. And it's really up to the family on how they want to create the family business. One issue as a lawyer that would come into play from a lawyer's standpoint would be whether or not it is intended that that document be a formal, legally enforceable, contractual type of document, or more of a mission statement kind of document. And the reason that matters is if you have a conflict between the family charter and other corporate formal organizational documents like bylaws or corporate resolutions or minutes, the question would be which one controls in the event of a dispute between them or a conflict. So typically, at least to my viewpoint as an attorney, I would see a family charter not necessarily as a legal document per se, but more of an informal family discussion, if you will, type of a document. Now, for purposes of this class, we're going to, as part of your project, one of the application number 1, you're going to be setting up a family charter. I want you to look at the appendix in the textbook for general layout, and that will be in the instructions on the Canvas page for application 1. All right, the next issue we're going to look at when it comes to structuring a family business is choosing what type of entity to use. This is going to be more of an overview discussion, just some basics about the different types of entities. So first of all, one of the issues that we're going to look at is whether or not you want to set up the entity to be subject to corporate tax. And essentially, with a corporation, there are two types of corporation, an S corporation and a C corporation. A C corporation is the traditional corporation, has unlimited number of shareholders. You could have one shareholder, or you could have 1 million shareholders if you're a publicly traded corporation. And it is the most flexible type of entity in terms of all of the different benefit plans and other type of structures for a corporation. The problem with the C corporation is it is subject to a corporate income tax on the profits of the corporation. And then when the profits are distributed out to the owners, the shareholders, which in a family business would typically be the family members, they also have to pay tax on those distributions of profit. So sometimes we call that a double tax, which means that the corporation will pay tax and then the owners or the family member owners will also pay tax. So it's subject to tax, and that's one of the main disadvantages of a C corporation. The other type of corporation is an S corporation, which is a small business corporation under subchapter S of the tax code. And it was designed and it came into being in the mid-'80s. And the idea of an S corporation was to allow for a corporation with all of the benefits for liability purposes and structure without having to pay the corporate income tax like you do in a C corporation. They're very popular for family businesses especially. There are limitations on C corporations on who can be an owner, however, which are far more strict than a C corp. A C corporation can have different types of owners, including entities or trusts or other type of owners. Where an S corporation, typically the owners have to be an actual person. It can't be an entity or a qualified trust for estate planning purposes. Now, the main reason we would choose an S corporation would be for the tax benefit. An S corporation is called a pass-through entity, and it is not subject to a corporate tax. The profits are distributed out, at least on paper, to the owners of the corporation, and then they will have to pay tax on those profits on their personal income tax return. And that will typically allow for an overall tax savings for the family business versus using a C corporation. The next type of entity, and a very popular type of entity, is a limited liability company, which we abbreviate as LLC. A limited liability company will depend on what state you're in, but it is probably the most flexible type of business entity. Typically, a limited liability company is set up either as a one-person entity called a single member LLC, or if you have more than one owner, you could set an LLC up with multiple owners as a form of a partnership for tax purposes. Or if you want to, you can also set up an LLC to be treated as either an S corporation or even a C corporation, although that's pretty rare. It is very common for LLCs now to be treated as S corporations for tax purposes, which allows you to realize some of the benefits of an S corporation when it comes to tax, but not have all the formal documentation that you normally would need for an S corporation. LLCs are probably, for a small business, especially small family business, one of the most common forms that are used currently to structure a family business. And they have a lot of benefits to them. That's why they're so popular. They're a fairly new form of entity. They've been around since the mid-1990s. And they become more and more popular really every day. Next, we have partnerships, which are not as popular as they used to be. There are various types of partnerships. The most basic type is called a general partnership. There are other types of partnerships, which may be a limited partnership or a limited liability partnership, or other forms of partnerships that have limited liability. They're taxed as a partnership rather than a corporation or individually, and that they were typically very common until LLCs came out in the 1990s, and now we don't see them being quite as common as they used to be. Now, the second point on your choice of entity is limitation of liability. And what we mean by that is whether or not the business entity structure will allow for protection, that is, limit on liability of the owner's personal non-business assets in the event of a lawsuit or a debt that cannot be paid or other type of claim against the business, maybe as a result of an employee causing an injury, or other type of incident that leads potentially to a lawsuit or a debt collection. Some of the business structures, such as S corporation, C corporation, LLCs, and limited partnerships, offer a barrier, which we call limited liability barrier, that will help protect the owner's assets that are non-business, like your house or your personal checking or savings accounts or your vehicle, non-business assets in the event of a lawsuit. And this is a critical thing. You want to make sure that you are not subject to personal liability in the event that there is a lawsuit or other debt that cannot be paid from the business assets and insurance and other financial assets of the business. You don't want to risk your house or other personal assets. Whereas a sole proprietor, if you're a single person or a general partnership, they have no liability protection, and those are generally disfavored forms of business entity structures, especially for a family business. So, as I indicated earlier, for most smaller family businesses, you're going to see either an LLC or an S corporation type of a structure, which seem to be the most common and popular types of structures for family businesses. All right, let's discuss some of the documents and filings that need to be done in order to establish a family business. I'm going to be a little bit out of order on this slide. I'm going to start with Secretary of State filings. To start a business, the first filing that needs to be done is with the state, and that is done with the Secretary of State, and those are forms that are provided by the Secretary of State, usually on their website, and that will include articles of incorporation for a corporation, articles of organization for an LLC, a partnership certificate or partnership articles for various types of partnerships. And then as part of those, you will list out the name of the officers, the members of the LLC, registered agent, which is the person that is authorized to accept legal papers on behalf of the structure, the entity, the physical address, and other similar information on those forms. You also are required to renew your entity every year, and that will need to be done with the Secretary of State, or if you do not renew, the state will dissolve your entity and you will no longer have the entity as a structure. As far as the organizational documents for the various entities, once you have filed with the Secretary of State, the articles of incorporation or articles of organization for an LLC or a partnership, that's the first step, or filing with the state. The next step is to put together the formal organizational documents, and this is where the organizational documents will really lay out the structure of the entity. It's sort of like the Constitution for the United States. It lays out the organization of how government is set up, and that's kind of a similar thing when it comes to these business entities. And this is where, especially with a family business, it's very important to have in place details about officers, any restrictions on sale, those kind of things. And we'll get into more of that in a minute. But first of all, we have bylaws for a corporation. The bylaws are the document that is the constitution of the corporation, essentially. It is the foundational organizational document, and that will, the document will contain information such as who are the officers of the corporation, president, vice president, secretary, treasurer. Are you going to have other type of officers? What their authority levels are, any limits on their authority. The bylaws will set forth who may have check writing authority, for example. The bylaws will also set forth how minutes and meetings are to take place in a corporation, voting rights. Also, if you're going to have different sorts of stock or ownership interest, maybe you're going to have voting and non-voting ownership rights. All of that will be detailed in the bylaws. Any credit authorizations or those kind of things, who has authority to sign contracts on behalf of the corporation, checks, loans, buying and selling, who has what authority. That's all going to be set forth in the bylaws. Similarly, for a limited liability company, the bylaws are known as an operating agreement. And that basically is the same idea as the bylaws, and will detail how an LLC is structured and who has what authority, if it's going to be voting, members, what authorities they have. If the LLC will be structured as a manager-managed LLC, where you have a manager or a president or other similar officers for the LLC, what authority they have, how meetings will be structured. You also, in an LLC operating agreement, may have provisions about restrictions on the sale of an owner's interest outside of a family, for example, transfer on death designations where their ownership would go if they were to pass away, buyout provisions if somebody wants to sell. So essentially it's the organizational document that lays out the ground rules for an LLC. It's a very important that, especially in a family business, that is the document that really is going to be the formal document in the event of a dispute or whatever. That's the first place a court is going to look, a judge, to determine what the rights of the LLC owners are in the event of a dispute. A partnership agreement is basically the same as an operating agreement for an LLC, only for a partnership, and it's essentially a contract among the partners where you'll lay out all of the organizational voting authority levels like you would with the LLC. All right, let's drop down to the bottom of the slide here and just talk real quickly about the IRS. Once you have filed with the state the appropriate form to get the business entity set up, you have bylaws or an operating agreement in place. You're going to also need to get what's called an employer identification number, or that's an EIN, or a tax identification number, TIN. They're interchangeable. And that's a form that you'll fill out called an SS4 form, and that is filed with the Internal Revenue Service on their website, irs.gov. To obtain, it's essentially a social security number for a business. And that is the number that you will need to go to the bank to open a checking account in the name of the business. It's also the number that you will use for all of your tax filings, including income tax, payroll, and any other type of filings. Another form, if you're going to be an S corporation or an LLC that's treated as an S corporation, you have to file an S corporation election form called a 2553 form. And this is a form that will tell the IRS that you want to be treated as an S corporation rather than a C corporation. And again, the S corporation is not subject to corporate tax. So it's very important that this form be filed. Otherwise, you will automatically be treated as a C corporation and subject to the corporate tax. Finally, if you're in Oregon, you will have to get an Oregon Business Identification Number called a BIN number. And the form that is filed is an employer combined registration form, which is available on the Oregon Department of Revenue website. And that is essentially the tax ID number for the state of Oregon. And then you will also have to update and use that number for your payroll taxes. All right, next let's discuss when we're talking about a choice of entity, and this is true for corporations, LLCs, or what have you, but the issue of officers and who will have and be making the major decision for the entity. And typically with a corporation, you will have, and this is required by Oregon law, you have to have a president, a secretary, and a treasurer as your basic officers. Now, oftentimes we will also see a vice president, but not always. But those are the requirements at the very most basic level: president, a secretary, and a treasurer. Typically, the president is in charge, an overall executive in charge. The secretary will be in charge of keeping minutes for meetings and documentation. And the treasurer, of course, will be in charge of the finances, check writing, and that sort of thing. Now, in a small business, like for example, I myself am an S corporation with my law practice. I only have one shareholder, and that's me. So I am the president, the secretary, and the treasurer. Depending on scale of the business, will depend on what officers you may have. Now, sometimes you'll have another layer of officers, maybe a higher level of authority than the president, vice president, secretary, and treasurer, and we would call those the chief officers. Maybe the chief executive officer is CEO, chief financial officer is CFO, chief operations officer, COO, chief legal officer, chief technology officer, etc. And that will often be, you see that pretty commonly in family businesses where maybe you have a higher level of an officer. Maybe they're not going to be doing the day-to-day things, so maybe you got the first generation as they transition to the second generation where maybe the parent is going to be the chief executive officer and maybe a child is going to be the president. So the president's going to do more of the day-to-day things. The chief executive officer is going to be more of a larger policy level decision making, making sure the president's not making mistakes and that sort of thing. And really that just depends on how you want to structure things. You can create whatever kind of officer you want. It just has to be documented in the bylaws or in the operating agreement for an LLC or whatever organizational document. So you have very clear discussion and limits on authority, authorization for various tasks, kind of a job description, if you will, for each of the officers. Now you will also, for a corporation, have to have a board of directors, which are usually also the owners of the business, but it may include non-family members or spouses. And again, the number of the board of directors has to be laid out in the bylaws. We usually like to have the number for the board of directors be an odd number. That way you can have a majority vote. Depending on what kind of decision making you want to have. Sometimes you may require a unanimous vote, majority vote, or a supermajority vote. For maybe sale of real estate might require a unanimous vote or a supermajority vote, whereas day-to-day decision making may only be a majority vote. And again, those type of issues are all going to be laid out in the bylaws or operating agreement for the LLC. You also, in the operational agreements, may want to require a non-family member executive, somebody from outside of the family to give, or more than one on the board of directors versus just all family members. That way you get some outside perspective, a fresh set of eyes on the problem, so to speak. I also like to include a very specific list of details on any limits of authority. For example, maybe check writing authority over a certain dollar amount requires 2 signatures, limits on opening credit cards, who can open a checking account or other bank accounts, who has authority to sign off on real estate contracts or loans. All of those authority levels have those well defined in the bylaws or operating agreement. And that really helps to cut down on potential disputes because it sets out the rules for the game, if you will, as part of those organizational documents. And that's where disputes oftentimes arise, where you have gray area, or you just don't have anywhere where it says who has what authority, and then people get into a conflict over who has the decision making. If you're going to have any voting by proxy, that's voting for somebody else. So maybe, for example, I was going to go on vacation and I wanted my spouse to vote my corporate shares at the next meeting. Well, we want to know if that's allowed or not, and we will put that into the organizational documents. Those documents should also set forth how meetings will take place, when and where, what kind of notice has to be given ahead of time so people can make travel arrangements if necessary. Will remote meetings by Zoom or even just an email, document exchange vote, those kind of things should all be set forth in the organizational documents, depending on the type of entity that you choose. All right, some other documents, just real quickly. Minutes of meetings. Anytime this is required for a corporation, in a way it's optional for an LLC, but I think it's a good idea as a best practice to have minutes for formal meetings of an LLC. And that, again, will depend on how the LLC is structured. But minutes are essentially a synopsis, notes, if you want to look at it that way, of what happened during a meeting. These are usually taken by the secretary, and generally the minutes will detail what sort of discussion was held, who was present at the meeting, the date and time of the meeting, where it was located, how the meeting was held, either face-to-face or by Zoom or whatever, by telephone. And then during the meeting, if decisions are made, for example, maybe we want to buy a piece of real estate in the family business, and so we have a meeting and we all vote to give the president the authority to enter into a contract to purchase property and to get a loan from a bank to buy that property. And so we will have what's called a resolution. A resolution after a vote of either the board of directors or the shareholders, depending on the type of meeting, and that will all be written down, and then it will specifically state where it is resolved that the president will have the authority to sign a purchase and sale agreement for the property, at XYZ Pine Street Road in Corvallis, Oregon, or whatever, and to enter into a loan agreement with U.S. Bank or whatever. And that specific resolution is a grant of authority on behalf of the entity to that particular officer or the agent, maybe the lawyer or whatever, to engage in those negotiations and close on the transaction. And a bank is going to want to see that. A lending company will require those resolutions. When you first start a corporation, you'll have a first meeting of the owners, shareholders, directors, and you'll have to keep minutes of that first meeting. And during that meeting, there's a lot of organizational setup that needs to happen. That includes issuing shares of stock, entering into a lease agreement, authorizing opening a checking account in the name of the business, who will have check writing authority, all of those sorts of issues, and those will all be in the first meeting minutes, and include resolutions authorizing the particular officer of the business to open a checking account or to get a corporate credit card or whatever. And it's very important that those minutes are detailed and authorized, and who voted on what was it a unanimous vote or whatever. Also, a shareholder agreement, and we'll get into that more detail in the next slide. A shareholder agreement is essentially a contract among the owners of a business, either a family business or non-family business, small type business, even if they're not family members. And these are limits typically on the transfer outside of the family or of the other owners of the business. And that brings us to our next slide. So shareholder agreements. A shareholder agreement, this may be a membership ownership agreement for an LLC or a partnership agreement. There are various different terms. But again, essentially it's a contract for the owners of a small or family-run business. And they're going to have various provisions. These are some of the typical type of provisions that you might see. A restriction on a transfer to a non-family member. That is, if you want to sell out of the family business, you can't sell it to anybody other than a family member, unless all of the other family members don't want to buy your share. Then maybe you could sell it outside of the family. Very common for small business, family businesses. A right of first refusal. This gives the other owners of the business first option to be able to buy someone that wants to sell their share. They have the right to refuse any offers that that person may get from third parties. You see this a lot in real estate transactions as well. An option to purchase is very similar. This gives the ability to purchase another owner's share, a forced buyout kind of situation. This might include if you had a family member or a small business owner, a partner, another owner in the business that died, or they got divorced or whatever. That way you could force them to sell you their share of the business, and that way you don't end up in business maybe with their ex-spouse or one of their children that you may not get along with, or they just don't know anything about the business, or they've got financial problems or whatever. And this basically gives you the option to buy the other owner's share in the event that something occurs where you don't want to be in business with another person for whatever reason that may be. Typically, we will also have a valuation paragraph in a shareholder agreement that will detail how the shares will be valued, an appraisal, or each side has an appraisal, you average them, or a CPA will do a valuation or whatever, how the cost for that valuation will be split. And oftentimes we'll include provisions that payments can be made maybe over a 10 or 20-year time period based on the prevailing federal interest rate at the time. Those kind of details would go into this type of an agreement. Also, dispute resolution, that is if any of the owners get into a dispute, how you resolve that either through third-party mediation, negotiation, that's a facilitated negotiation, or maybe arbitration, where you have a private arbitrator acts like a judge, maybe a multidisciplinary evaluation with a lawyer, a CPA, or other type of professional. There are multiple ways, hopefully not having to go to court. And then finally, an anti-dilution agreement. This is a provision that essentially says that the corporation will not take any action to reduce the voting power of an owner. It's called dilution, by issuing additional shares of stock, for example, but not offering the same pro rata number of shares to the existing owners. So those kind of issues are what we would typically put into a shareholder type agreement. And then it should also be indicated on the share of stock for a corporation, the share certificate, that the ownership interest or an LLC ownership membership interest certificate, that it's subject to these restrictions. That way, if somebody tries to sell it on the share, the corporate stock share, it says restricted right on that share certificate. All right, so in conclusion, we've talked about some of the various different organizational documents, family charter, corporation, the bylaws, the minutes, shareholder agreements, LLC, operating agreements, sale restrictions for non-family members, partnerships. I just want to conclude by just pointing out that, especially with family business, a lot of these very formal legalistic documents sometimes aren't done. In fact, it's pretty common that they're not done. Family, well, we don't need those, we're a family. And that's a real problem that I see as a lawyer. And that's where a lot of time disputes can come up, especially if you have siblings or the next generation, they don't get along. As a lawyer, the first place we're going to go look is to see what documents are in place, any amendments or changes, or If there are no documents, is there law that will fill in the blanks? And it's really very important, even with a family, and sometimes more especially with a family business, that you want to make sure you have these documents in place, because if a dispute arises, that's the first place we look. But more importantly, it can limit or it can stop disputes before they occur by being properly organized so everybody knows the rules of the game, everybody knows who has what authority. If you have siblings that are maybe feeling one's a favorite child versus another from the parents, it gives some structure to that family business where otherwise you may not have that because it's more of an informal type of, it's a family business. Well, we don't need that. And that can lead to real problems. And that will be the end of this presentation.